Good morning. So I'm Chris Boccinfuso. I'm the provincial specialist for the Ministry of Labour on workplace violence and harassment. I also carry the education portfolio, thanks to my colleague here, and there's a lot of education folks here, so good to see you all. And so if Jeff was talking about where the rubber meets the road, I guess I'll talk about the skid marks. So what I'm going to do today, I'm really just focused on harassment. But I'd like to, there we go, do just a very quick overview of how we got here. Then we'll take a look at the data that I've got, because we seem to be a very data-driven organization, and you guys seem to like data, so I can bring data. Take a look at just sort of how our side of things break down by sectors, and then we'll open it up and we can have a back and forth. And if you have questions as I go through, please go ahead and ask them as we go along. So I also don't have graphic designers at my behest, so this is the ultimate skill that I have with PowerPoint. It's good. I was really excited to get to this. So where do we start? So workplace violence and harassment came before 2010. We didn't really have workplace violence and harassment in the Occupational Health and Safety Act, and we were dealing with it from using 25(2)H. Right, so our general duty clause, and I don't think that it was really consistently looked at, and it certainly wasn't something that was highly on the Ministry of Labour's radar at the time. And then after the Laurier Dupont murder in Windsor, and we moved through the inquest, then there were some changes, and Bill 168 came into being, which was really mostly focused on workplace violence. And there were quite a few different elements for the workplace violence program and the policy, and the inclusion of domestic violence in there. And then harassment was added in because we recognized that harassment sits on a continuum of violence, right? So unchecked harassment moves into workplace violence, and they can rapidly move back and forth between harassment and violence. So it was included, but as we all know, back in 2010, what we had was some light touches, I guess, if you will. Have a policy, have a program, move along. And I think we recognize, certainly the inspectorates, experience, if you will, as they went through, was that harassment was very difficult to deal with. But we started back then having an uptick in discussions as a ministry with our clients around harassment, right? So we moved along, and then Bill 132 came along as part of a wider government initiative. And they really beefed up the workplace harassment side of things. And so now there's a number more elements. There's some positive duties that include a duty to provide information to people on an investigation. There's a duty to do investigations. There's a duty to provide written results to people, and a much broader and a much deeper program to deal with harassment inside the workplace. And we got resources to deal with that. We got to hire 12 new inspectors, which didn't even come vaguely close to dealing with the amount of work that we did. And previously, we were seeing things between the implementation in 2016 and 2017. When you take a look at the numbers, you'll see that there's like a 168% increase in the amount of work that the Ministry of Labour was doing between those 2 years. So this is how we got here. Just to sort of give you an overview of where things sit, the most recent data that I have was 2017. I'm hoping that one of my colleagues will do this work for 2018. But these are the top 5 areas where inspectors have written orders in all sectors, all across the province. And you can see here that workplace violence and harassment orders outstrip the next set of orders by several thousand. So we're looking at close to 12,000. I round much more broadly than John does. But we're looking at roughly 12,000 orders in 2017 around workplace violence and harassment, where fall arrest and this is primarily in construction, you're looking at 9,000, right? And then it starts to drop really, really quickly. Until we get down to number 5, which used to be the top administrative type orders around health and safety representation and committees, where we're easily double the basic orders. Yes?
Healthcare, it's not showing any contraventions for the healthcare sector. What is
Right. So the healthcare sector is actually wrapped into the industrial sector. These numbers are based on where the inspectors actually their reporting relationship. And there was a time when we had inspectors who are dedicated strictly to healthcare. And now that we've broadened out, the healthcare inspectors have also healthcare and an industrial focus. So that's more of an internal accounting than it is anything else. So here's what I'm going to look at to break down harassment for you folks. 2016, 2017, 2018, you'll find the 2016-17 data is a little bit lower. You'll remember that the Royal Assent came into being and then the legislation kicked in on September the 8th. So there were no orders possible in a number of sectors in that 16-17 time frame until after September the 8th. Okay, and when we talk about events, we're based on, these are events that have come into the Ministry of Labour Contact Center, and they are generated from there. So where you can see here, the complaints start around 2000. We were surprised to discover that the rise and the difference between 2017 and 2018 was actually much, it was flatlined. Now, I think it's a little too early right now to decide whether or not we've plateaued in terms of complaints coming into the Ministry of Labour, but certainly the numbers are showing, in fact, dead even to 2017, 2018, but a significant jump when the legislation came into being. And we had a real switch where in 2016, 2017, we were running about 70% administrative contraventions being called in, so a lack of a policy, a lack of a program, and about 30% of the calls in 16-17 were about harassment actually taking place, and it's completely flipped on end. So now the vast majority, closer to 80% of the complaints that come into the ministry are now around lack of an investigation or failure for an investigation to actually be appropriate in the circumstances. So that's where we're sitting now. About 80% of those are coming in now. The vast majority of them come in through the contact center as phone calls, but there are online ways to bring complaints into the Ministry of Labour. So the total unique workplaces, so what could happen is you may be a workplace that had several complaints, but you'll only count once in that column, where complaints are irrespective of workplaces, but it gives you an idea of 30,022 complaints last year in 2,597 workplaces. Right, so it's there. And then the number of field visits that are being made by inspectors, so that can be with respect to another case or to single cases. So one complaint comes in, we often have 1 to 2 field visits that are made by the inspectors, predominantly to the employer, and that wouldn't include client contact time. So when a complaint comes into the ministry, it gets assigned to an inspector. An inspector probably will spend 45 minutes to an hour talking to the complainant before they walk into the employer and make their first field visit. So they've got a good amount of information there before they've walked in. So you can see we're a little more efficient than we were last year, and I think that's because the inspectors are now into the swing of how to deal with this legislation. It was difficult in the beginning. We had a team of about 40. Within 3 or 4 months, we had decided that we needed more closer to 100. And by the end of the first year, by the end of fiscal year 2016, 2017, I was ramped up and I was on a tour of the entire province to train all of our inspectors in how to deal with workplace harassment complaints. Thunder Bay in February was lovely. It was actually nicer than Toronto. So these are the administrative orders that we wrote, and you can see that the numbers administratively pretty much stay the same as you go along. Establish a policy, review your policy annually. These are proactive and reactive numbers. So these are, inspectors, of course, are doing approximately 30 to 40% of their work is being done proactively, where they pick a sector, they go into a business without any complaint or any reason. They will go in and they'll include an audit for workplace harassment and violence provisions as part of their regular jobs. So these orders reflect both a complaint and proactive work. Policy, having a program, missing elements in the program, and reviewing the program annually. So those are pretty steady numbers across the board. And this presentation will be open and available for sharing, obviously, because I don't think you want to write down all these numbers as we go along. So these are the employer duty. So these orders here, while they could have been written on a proactive inspection, would more typically be written in a reactive. So these are going to be the orders that are written on investigations where people have run into a complaint and then the inspector has gone out to look into it. So massive jump between 2016 and 2017 to from 236 orders to 700. Dropped a little bit in 2018-19, but they're still pretty much on par. Providing written results is on par. Policy and instruction, generally you're not going to get those orders if you don't have anything in place. We would order you to develop your policy and program, and then there would be an expectation that you would do your own training. Everyone was quite worried about orders for impartial investigations. However, what we found in our experience is that workplaces want to be in compliance. They don't want to cross a ministry. So when we give them an order to do an investigation, they seldom require the direct reinforcement of being told to get an impartial party. Without our help. And generally, you can see from the numbers, they were particularly belligerent cases, and we have some safeguards in place to make sure that those orders are written appropriately. So by sector, and I think that this is where the previous research that John had is going to differ a little bit. So one of the things that I look at when I look at where this comes is, why are these people coming to us? And why are people coming to the Ministry of Labor? And in general, people are coming to the Ministry of Labor from the sectors that have the least other options to seek redress to their problems. So we see that they're coming from sectors that are traditionally non-unionized, that are traditionally outside of a collective bargaining, so they don't have a different venue to go to seek redress for that. So that's why some of our sectors differ in terms of what the broader people reporting harassment are, but these are the people who come to us because they have no other place to turn. So construction and mining are really not on the map in terms of complaints when you look at the numbers. The vast majority of things are happening within the industrial sector. I'll break down the industrial sector in just a sec a little bit more for you. Healthcare is seeing a good number of complaints, but I think that healthcare is still working its way through violence in a big way. And once healthcare moves past violence, then we'll see where harassment's going to fit in. In the industrial side, how we break down by sector really comes down to, as I said, retail, restaurants, office services, and industrial services, food, beverage, and tobacco. So they're exactly the kind of places where you have lower wages, higher employee turnover, you've got less job security traditionally in these sectors, and you have less avenues to go through in order to seek a remedy when you run into harassment as a problem. So this is these are the only place that they can come to the Ministry of Labor and ask for these sort of redresses to come through. So that was the exciting part of the presentation. Leon left because I'm a loose cannon and I'll pretty much answer any question. And he didn't want to be here to have to deal with that, but. Thoughts on where we have with this. I think that, again, we deal with the tough part of things, and we don't deal as much with the harassment side because I'm on the enforcement side. We do have the code of practice, which was put out there, And many employers are using it. Hopefully you're familiar with it because it does provide an excellent roadmap to having a robust policy and program and how to do investigations. We're dealing a lot with some things that we had to discover as we went along. The Occupational Health and Safety Act is based on a worker-employer relationship. And we run into situations where that worker relationship with an employer isn't always immediately obvious, or it may not exist at all, and yet the complaints still come into us. So there's been some learnings on those side as well. There has been no case law built out of this. There's some items that are at the Ontario Labour Relations Board, and I've written some lengthy will-say statements for our lawyers recently, and they plan to put me up on the stand, which is very, very exciting. But there's no case law, so we're still working out what appropriate in the circumstances means, and how to select an impartial investigator. So we run into a lot of complaints around those. There's questions that get asked about what happens when harassment is taking place outside of sanctioned employer-employee engagement. So if, for example, you are released from your employer to go to a union function and harassment takes place, what happens there? Who has a responsibility? Under the Act, it says the employer has a responsibility, but it conflicts with the Labor Relations Act, which says the employer shouldn't be involved in things that are happening on union time. So we run into some conflicts there, and we're working through those from a policy standpoint to just sort of build bridges and ways around those. But I'd be happy to discuss any of your experiences. Far back. Yeah. So the question was, do we have an idea of what the impact on the individual who felt that they were making a complaint to the ministry was in terms of health impacts or whether they were employed? So anecdotally, we don't have this scientifically, but anecdotally, about half of the complainants no longer work at the workplace. So they've either been unwilling to stay in that situation, or they've been terminated. So there's a possibility that, along with her seeking their rights to be looked at, they may have been reprised against. So there's a possibility that exists. But about 50% have left the employer either voluntarily or involuntary. I couldn't speak to health effects because we don't necessarily record that sort of information.